Maybe,
Yes.
Your Lordship,
Yes.
Your Lordship, if Your Lordship will allow us to mention from the supplementary hearing matter, Your Lordship, I'm sorry to say there's some in the impugned judgment. In the judgment, there are some portions which are in Mizo language. So Your Lordship may find some difficulty.
Yes.
If Your Lordship will kindly see page 219, for example, of the paper
Yes,
book.
yesterday I have gone through the same.
Yeah, there are certain portions which are in Mizo language. So if the registry may be directed to translate those portions.
Okay.
Otherwise,
Then
Your Lordship will...
When to be listed then?
10th, so November 10th. 10th of November, Your Lordship, that's a Monday.
10th of November.
Yes.
Okay. Okay. I will pass the order.
Yeah, those translation
Yes, yes. For translation to English.
in the judgment passed by the trial court.
Yes, yes.
Certain portions are in Mizo language.
Yes,
they
yes,
may
yes.
be translated.
Okay. Okay.
One moment.
My Lordship, with Lordship's kind indulgence, I beg to mention one unlisted item to be listed tomorrow, my Lord, not today. So it may kindly be listed.
What matter?
It's a CRP, my Lord, Civil Revision Petition.
Civil revision petition. Okay.
Tomorrow.
Okay.
Lordship, may I seek for Your Lordship's indulgence in making a mention of unlisted item, my Lord. I filed one criminal appeal on last Monday. This is regarding corruption matter.
When do you want?
It may be taken up today, my Lord, because
Today? Okay, yes, last item.
Yes, much obliged, ma'am.
For motion, item number 1.
Lordship, wait please, Lordship. The petitioner herein are the owner of the land passes under the Land and Revenue Settlement Department, Chakma Autonomous District Council within Longklai District. And the respondent have taken step for construction of 14 BOPs fencing within Longklai District by the BSF under the Ministry of Home Affairs, Government of India, for maintenance of national security along the Indo-Bangladesh international border. That
But,
notification,
Madam,
yes,
you tell me, the land was acquired
yes,
under section, under Mizoram
yes,
Land Acquisition,
Yes.
Rehabilitation and Resettlement Act 2016.
right,
That act was invalidated by the division bench.
yes, set
in
aside,
Writ
yes,
Appeal number 70 and
Yes,
71
yes.
of 2018.
yes,
So the notification issued by the government has lost its significance.
Your
So
Lordship,
they have rightly withdrawn the same.
Your Lordship, I have one judgment I have enclosed, wherein it is stated that let them pay it first, which was made under section 2016, and after that assessment will be made under 2013. That judgment I have. So they have made a word under 2016, and which was approved, and they have to pay first, and after that they have to make under 2013, deducting the award already made under 2016. That judgment I have. Your Lordship, kindly see the judgment.
That judgment is of which court?
This court,
Okay. Page number?
page number 167. Your Lordship. Not that, Your Lordship, I'm sorry. 164. Six, seven, 164. Okay. Hiin ang sa kanya. 164. This is the, I'm sorry, this, yes, Your Lordship, Annexure 27, 167. Kindly see the, I'll read the operative portion only, Your Lordship. So I read from the
Paragraph number?
11, page
11.
174.
Yes, yes.
Your Lordship, thus in view of the common judgment of the Learned Division Bench dated such and such, the above observation of coordinated bench of this court in WPC relied upon a coordinate bench in WPC number such and such, disposed of by a common order dated and also considering submission made by the Learned Counsel for the respondent, this court finds it appropriate to pass an order similar to those passed by the coordinate bench of this court, such and such, disposed of by a common order dated 21/11/2024, by directing the state respondent to take necessary steps to pay compensation to the petitioner under the right to fair compensation and transparency in land acquisition, rehabilitation, Resettlement Act 2013, with all the consequential benefit after deduction of the amount already received by them under the Act of 2016. So, Your Lordship, without going back to the phrase, let them pay already made, what already made.
No, in that case, perhaps a payment has already been made
Yeah.
under the
Yeah.
Act of
Yes, Your
2016.
Lordship, in this case, what
But
is already
in your
made.
Case, but in your case, award has not been, no, so award was passed,
Yes,
but the payment has not been made.
that is correct. Your Lordship, what I'm praying
Now,
is that,
Madam, you say the act is no longer in force.
right,
Would it be proper to direct the state respondent to make payment under the said act?
yes, if direction is made.
Yes, or who is appearing for the state respondents?
Yes, Your Lordship. Reading the judgment and order which the Learned Counsel had mentioned, Your Lordship, here it is clearly mentioning that the amount, the award which has already paid has
Paid.
to be deducted.
Yes.
As per the Act of 2013. So, Your Lordship, in this case, the award has not been pronounced. It is made,
Yeah,
but not yet
it's
pronounced. Not
already
given-
approved.
It's
Lordship,
already approved, but it was
way
not
back in 2020.
paid to them. So it is still in the hands of the state. So the award, which is already approved, has to be again reassessed under the Act of 2013, as per this judgment.
Now the question is whether the state is going to acquire the land again under the Act of 2013.
In that regard, I have to take instruction, Your Lordship.
You have to obtain instruction.
Even though, Your
Okay,
Lordship,
Madam,
one thing-
at this it says let notice go, we will say.
yes, Your Lordship, in the meantime, status quo may be maintained.
No. Well, first let her obtain instruction, thereafter your interim period will be considered.
Your Lordship, the thing is that this order, impugned order is was passed. Previously, you have filed this case. During the pendency, they have made this order revocation. So without waiting for the outcome of the petition. So during the pendency, they may make another thing, just status quo, as it is.
Let her obtain instruction first, thereafter we will consider your interim period. Heard, Ms. T. Arzu, Learned Counsel for the petitioner, and also heard Ms. Madam, your good name, please. Madam, your good name.
Vanay Siami.
Learned, government advocate,
Yes, Your Lordship.
government advocate for the state respondent number. All the respondents,
4, 5, 4 and 5.
4 and 5. And Madam? 1, 2, 3. 1, 2, 3. In this petition under Article 226 of the Constitution of India, the petitioners have petitioners have challenged the notification dated 7/5/2025, Annexure 25, issued by the state respondents, and also to direct the state respondent to sanction the compensation amount in terms of the approved award number 1 of 2020 and disperse the same to the petitioners immediately, and thereafter direct the petitioners to make new assessment in terms of RFCT LAR Act 2013 and to make payment accordingly to the petitioners. Alternatively, it is also prayed that in the event of award number 1 of 2020 is cancelled, the respondent should be directed to pay adequate compensation towards damage struck rent to the petitioner in terms of Section 93 of the RFCT LAR Act 2013. The grievance being sought to be addressed in this petition is that the petitioners are the landowners and possessing their respective land passes issued by the Land Revenue and Settlement Department under the Sakma Autonomous District Council within Langklai district. The state respondents have taken step for construction of 14 numbers of BOPs fencing with Langklai district by the BSF under the Ministry of Home Affairs, Government of India, for maintenance of national security along the Indo-Bangladesh international border. Thereafter, notification under Section 11(1) of the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 was issued on 17/7/2017. And after completion of the process of acquisition, including spot verification and ascertainment of the genuineness of their land, the Deputy Commissioner Deputy Commissioner Langklai District made draft award number 1 of 2020 on 16/9/2020. Including the name of the present petitioners. And subsequently, the said award was approved by the government on 16/10/2020. And clerical error in the area of the land to be acquired was corrected by the state government on by the Deputy Commissioner and approved by the government on 25/11/2020, followed by issuance of corrigendum on 21/12/2020. But the petitioners have not been paid their respective entitlements in terms of the award number 1 of 2020. And subsequently, a division bench of this court in WA number 70 and 71 of 2018 by judgment and order dated 30/10/2020 have held that the aforesaid Act of 2016 is inapplicable within the state of Mizoram. Thereafter, the state respondents have issued the impugned notification dated 7/5/2025 revoking the approval of the said award. Being aggrieved, the petitioners approach this court by filing the present petition praying for the relief mentioned herein above. The learned counsel for the petitioner, relying upon a decision of a coordinate bench of this court in WPC number 127 of 2023, submits that the petitioners, the state respondents may be directed to make payment to the petitioners as per award number 1 of 2020, and thereafter to reassess the compensation which they are entitled to under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013 by deducting the compensation already paid under the Act of 2016, and she also paid for staying the impugned order dated, impugned notification dated 7/5/2025. The submission of learned counsel for the petitioner needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step be taken upon respondent number respondent number 6 to 9 by registered post with ADN also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4 and 5, since they are represented by the learned government advocate and also by the learned CGC. You are CGC? CGC. However, extra requisite copy of the petition be furnished to them during the course of the day. It is further provided that the learned government advocate for the respondent number 4 and 5 shall obtain instruction as to whether the respondent number 4 and 5 are whether the respondent authorities are going to acquire the land of the petitioners again under the Act of 2013. List the matter after a week,
Yes, 10, on 10.
10th of November.
Yes.
Okay, 10th of November.
Lordship, in the meantime, during the, before 10, they may take step again. So it's status quo, just status quo.
No, on that
Till-
day we'll consider.
They, because I'm worried that previously you have filed the same case. During the pendency, they have made this impugned order. So we have again challenge. So
No,
just
no,
for the
now-
returnable
No,
date.
no. Now there is no question of passing any impugned order. They have already passed
They
Yes.
already cancelled them.
They might take step
for
for cancellation of the award. Award
cancellation.
is not yet cancelled.
No, Your Lordship, as per their statement, it is already revoked, the approval.
Yeah, approval only
The
revoked.
approval is already revoked, and there is no urgency whether they will take step or not, because it is already revoked.
Yeah, it's
And the
revoked.
only step what they have to take is that
if
whether-
you have
whether
challenged
they
this
will acquire the land or not.
revocation order, Your Lordship.
If it is already revoked,
If
so there is no other step to take.
if not stay or if not status quo is maintained, they might cancel award again. Because, Your Lordship, as you know, notification was issued in the year back 2017. You have waited for so long.
However, taking note of the submission of learned counsel for both the parties, it is provided that any further action upon the award being passed by the respondent authorities shall be subject to the outcome of this petition. List accordingly.
Item number 2.
May I please, Your Lordship?
Yes.
My Lord, the petitioners hearing were selection grade officers under the Mara Autonomous District Council we're challenging the promotion, illegal promotion of the respondent number 3 and 4 who in the post of having grade level 13A of the pay matrix, my lord. In terms of the relevant recruitment rules, and as per the procedure, my lord, they were illegally appointed to the said post, respondent number 3 to the post of under level 13A, which is specifically meant for general service wing. Respondent number 3 belongs to technical wing. And besides that, my lord, the respondent number 4, although he was junior most amongst them, he was illegally and arbitrarily appointed to this post without first considering the case of the petitioners. So we are challenging their promotional.
You first tell me, you were challenging the promotion of respondent number 3 and 4.
Yes, my lord.
3 and 4.
3 and 4.
But you come to your pair person.
Yes, my lord. My first prayer, my lord, this is in respect of promotional order of the
Respondent number 3.
respondent number 3, my lord.
And number 2 is for in respect of respondent number 4.
Yes, my lord.
Okay. Who is for the respondents?
They do not have standing counsel, my lord. I'll have to take steps upon them.
Pardon?
They do not have standing counsel. They do not have standing counsel. I'll have to take steps, my
Okay.
lord.
Okay. Heard, Mr.
Victor.
Learned counsel for the petitioner. In this petition, under Article 226 of the Constitution of India, the petitioners have challenged the challenge the notification dated 8/7/2024, which will make it Annexure 11, by which the respondent authorities have promoted the respondent number 3 to the post of
To the post
Secretary.
of secretary to the district council.
secretary to the district council, and also challenge the challenge the notification dated 10/10/2024, which in bracket Annexure 20, in respect of promotion of the respondent number 4. Respondent number 4 to the post of,
Court president and recorder.
pardon,
Court president and recorder.
court residence and
Recorder.
recorder
Yes, my lord. Under the Mara Autonomous District Council.
under the Mara Autonomous District Council, which will make it MADC. MADC. The learned counsel for the petitioners submits that the respondent number 3 and 4 are junior to the petitioners.
Respondent number 3 belongs to different wing, technical wing.
Technical wing.
And the promotional post is specifically meant for general service wing. The petitioners were belonging to general service. And the respondent number 4, being the junior most, he cannot be considered ahead to the petitioners. So far as the case of the respondent number 3 is concerned, he belongs to a technical wing, and he was promoted to the post meant for general service.
The petitioners are from general service,
Yes, my lord, all of them.
and respondent number 3 is from
Technical wing.
technical wing. And respondent number 4 is the junior most.
He is the junior most, and he was promoted to the
The
referred
learned
post.
counsel for the petitioner further submits that the petitioners are from general service, and the respondent number 3 is from technical wing, and respondent number 4 is
Junior most.
junior most employee. And the respondent authority ought not to have considered them to the aforementioned post. And being aggrieved, the petitioners approached this court by filing the present petition as the action of the as the promotion of the respondent number 3 and 4 or arbitrary and illegal. Peruse the petition and the documents placed on record, and also peruse the impugned notification dated 8/7/2024, promoting the respondent number 3 to the post of secretary to the district council, and also the notification dated 10/10/2024, promoting the respondent number 4. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Interim pair of the petitioners will be considered on next date, next returnable date. List after 4 weeks.
Deeply obliged.
Item number 3.
May it please Your Honor. Lordship, I appear on behalf of the petitioner Lallian Tluang Asylum, Lordship. Lordship, what this writ petition seeks is that, Lordship, the petitioner has been appointed as a Group D, Grade 4 driver, Lordship, as a Group D employee, Lordship. Now, Lordship, he has been asked to perform the duties of a Group 3, Grade C, Lordship, driver. Lordship, so what happened was that in his initial appointment, Lordship, he has been appointed as a Group D employee, Lordship. And as per the recruitment rules 2019 of Group D employees include peon, chokidar, sweepers, Lordship. However, Lordship, his appointment has been made as a driver, Lordship, whereas the driver has a separate rules and regulations, Lordship, and it is a separate post and a cadre, Lordship. Now, if I may take your Lordship to the appointment of the petitioner, Lordship, the petitioner was appointed on 30th May 2011, Lordship, which is given in annexure number 3 and 4, Lordship. If I may go to Lordship, page number 32.
Yes.
Yes. So, office order. As per the recommendation of DPC held on 23rd May 2011 and subject to production of medical certificate and police verification, Lallian Tluang, son of Vanal Sanga, Dinthar Veng Ser Chief, is hereby temporarily appointed as 4th grade at Jain Hospital Ser Chief in the pay band plus pay grade of rupees 4,440 to 7,440 plus 1,650 per month plus allowances, plus all other allowances as admissible under the rules with effect from the date of joining. Now, Lordship, after this appointment, Lordship, he submitted his joining letter, Lordship, and the joining letter is on page number 33, Lordship, which is annexure number 4, and the type copy is given in page number 33A, Lordship. So now, Lordship, after he submitted his joining report, Lordship, even his joining report had been submitted, forwarding of has been submitted to the Director, Hospital Medical Education, Lordship.
No, but the question is whether any post of driver exists in the said department.
No, it doesn't exist, Lordship.
Then
It is a separate post, Lordship. It is a
Then-
complete separate post with cadre, Lordship. So, Lordship, what happened was that he was employed as a Group D, Lordship, but his service was utilized as driver, Lordship. Even his service of employment has been modified, Lordship. The modification is given on page number 35, Lordship. And the English translation is given on page number 35A. If I may go to Lordship. Yes. To the Director, Hospital and Medical Education, Aizawl, Mizoram, prayer for making correction in order. Sir, as per your letter number such and such dated 30/5/2011, Lallian Tluang, son of Vanal Sanga, Dinthar Veng Ser Chief, have joined JN Hospital Ser Chief as per his appointment as 4th grade on 1/6/2011. But due to shortage of driver, and since he bears good character and possesses driving license and also skills of driving vehicle, and since he has been utilized as driver since the date of his appointment till date, I do hereby request you to make changes to his appointment order as 4th grade cum driver, Lordship.
Thereafter, whether any order was passed?
Yes, Lordship. Order has been passed, which is given in annexure number 37, page 6, Lordship, the foregoing page. Now here, what the order says is that in the interest of public services, Pu Lalian Tluanga, which is the petitioner, 4th grade at Jain Hospital, is hereby placed to work as driver. Now, Lordship, till date, Lordship, the petitioner service has been utilized as driver, Lordship, since 2011. Well, there is a separate post, a separate regulation, rules regarding Group 3, Grade 3 drivers, Lordship. And there are differences in pay and benefits, Lordship. Now, Lordship, even this, even the petitioner service, which is utilized as driver, which he has been working for the past 14 years, has also been acknowledged by the same authority, Lordship. It's given in our annexure, Lordship. Lordship, it's given in page number 43, annexure number 13. Now, the English translation is given in page number 43A. Yes, so if I may go through, Lordship. To whom it may concern, I do hereby acknowledge that Lalian Tluanga Silo, Group D staff, have joined his service on 30th May 2011 at District Medical Superintendent Chief, and that since the date of his joining, his service has been utilized as driver till date at District Medical Superintendent Chief. Now, Lordship, what the petitioner has been appointed was as a Group D driver, as a Group D employee, Lordship. It does not include driver, Lordship. The driver post is on a separate regulation for that, Lordship, which is the Mizoram Driver Rules 2018, Lordship. Now, yes, Group C, Lordship. Now, Lordship, even the petitioner have, after his appointment, Lordship, he was confirmed in his post in the year 2015, Lordship.
Okay, let notice go at this instance. Yes, madam, you are appearing. But if the post of driver does not exist there, then what to do?
Now, Lordship, what happened was in this Group D, Lordship, which is, if I may kindly take you to, Lordship, the rules. It's given in page number 44, annexure number 14, Lordship. This is with regards to Group D employees, Lordship. Yes. So here, Lordship, in page number 46, Lordship.
What is the difference of scallop pay?
Lordship, over here it is 17,400 to 38,600, Lordship. And whereas in the driver, Lordship, in the grade 3, Lordship, the salary is comparatively much lower than the Group D, although, but there are no any promotional avenues for the petitioner, which is in the Group D, Lordship. Since his service has been utilized as driver, Lordship, since for the past 14 years, now he doesn't have any promotional avenue, Lordship. Just Group D is the final post which he can achieve, Lordship. But whereas whereas there is a separate post, which is the driver post, Lordship, he has not been absorbed in the post, neither has it been given any promotional avenue in this post, Lordship. Now, also, Lordship, if I may take you to page number 45, Lordship, which is para number 7, Lordship, section number 7, Lordship, which is power to transfer, Lordship. Page number 45.
40?
Number 7, Lordship, power to transfer. Page number 45. Page number 45, which reads number 7, power to transfer. Yeah. So, Lordship, if I may go through. Notwithstanding anything contained in these rules, the Governor of Mizoram, in public interest, shall have the right and power to transfer any officers so recruited under these rules to any other post or position which is equivalent in rank or in grade. Now, Lordship, when the petitioner is in fact in Group D, Lordship, he has been transferred to a separate rank at separate grade, Lordship, which is a complete separate grade, Lordship. And even in the Group D rules, Lordship, driver is not included anywhere, Lordship. Group D post includes, Lordship, it's given in page number 46, name of the post, which is peon, chowkidar, sweeper, and other Group D posts, Lordship.
Yes, madam?
Your Lordship, if I'm to argue on the issue, this seems like a matter of issue of law, so, and also have to gather their input as well, Your Lordship. So if I may be granted time to gather instructions. At the onset, Your Lordship, the first issue which arises is after 14 years, and during that 14 years, the petitioner did not have any kind of complaint as to his work.
If
or
I
his
may,
duty.
Lordship, the petitioner has in
Let
fact...
her
Okay,
complete.
okay.
So, Your
Yes.
Lordship, that the question arises as to why, after 14 years, the individual, the petitioner, has come before the court, and can he be given the post of a driver as an entitlement to a right when his initial appointment is of a grade 4, I believe,
Grade 3,
grade 3,
Group C.
grade 3, Group C.
Okay, you obtain instruction then.
Yes, sir.
Heard, Mr. Your good name, please.
Samuel Patsua, Lordship.
Learned counsel for the petitioner, and also heard Ms. So-and-so, learned government advocate for the state respondents. You were representing all the respondents?
Yes, Your Lordship, 1 to 5.
1 to 5. The grievance of the petitioner is that he was appointed on 30th May 2011 as grade 4 within Group D staff of Jain Hospital, Sarship. But since the date of his appointment, his services have been continuously utilized as driver due to departmental exigencies. The learned counsel for the petitioner submits that the petitioner has submitted several representations since the year 2016 requesting upgradation and regularization of his service as driver grade 3, but the same failed to evoke any response from the respondent authorities. The learned counsel for the petitioner further submits that the drivers are governed by rule
Page number 17, Lordship. Mizoram Driver Recruitment Rules 2009.
Mizoram driver recruitment rules 2009, 2009, whereas the Group D employees are governed by the rule Mizoram Group D Post Recruitment Rule 2019, and the pay scale of the driver is higher than the Group D.
The higher, and also there is a promotional revenue as well, Lordship.
Higher than the Group D employees, and there is also promotional avenue in the said category. And having utilized the service of the petitioner as driver without giving him pay and benefit, he is subjected to exploitation and forced labor, thereby violating the provision of Article 23 of the Constitution of India. And therefore, he has applied for issuing direction to the respondent authorities for convening a departmental promotion committee to consider the case of the petitioner for being appointed to the post of driver grade 3, Uttarakhand Brigade Group C, by taking into account his continuous service as driver since the date of his initial appointment, that is 6th of January 2011, and to extend the consequential
Lordship, if I may make a slight correction, not
service of the
6 January.
service and financial benefit.
It's 30th May, Lordship. We made a small error here, Lordship. It's not 6 January.
30?
30th of May, Lordship, 2011, not 6 January, Lordship. We made a
But
slight...
it is in your petition.
I understand, Lordship. I just noticed this. My sincere apologies, Lordship.
Okay. 30th?
30th May 2011.
May 2011. 11. Ms. So-and-so, learned government advocate, appearing for the respondent number 125, however, submits that the petitioner has approached this court after 14 years, and he has not made any objection earlier. However, she submits that she may be granted some time to obtain necessary instruction. Having heard the submission of learned counsel for both the parties, this court is inclined to issue notice to the respondents returnable in 2 weeks. However, no formal notice is required to be issued since all the respondents are represented by Ms. So-and-so, learned government advocate. However, extra requisite copy of the petition be furnished to her during the course of the day. Lays the matter after 2 weeks. In the meantime, learned government advocate shall obtain necessary instruction and place the same before this court on next returnable date. List accordingly.
Much obliged, Your Lordship.
Item number 4.
May it please Your Honor, Lordship. This
Same
is
matter.
a similar matter, Lordship. Just the appointment dates are
Similar
different.
order.
Item number 5.
Much obliged.
May it please Your Lordship.
Yes.
As my Lord, this writ petition is filed by the petitioners against the respondent, and wherein we, the petitioners, we were awarded a compensation in respect of the NH06 in the stretch of land from kilometers 138.55 kilometer to 141 kilometer at Kolaship, District Kolaship. And the 3A notification was issued on 14/03/2024. But the respondent illegally deducted a 15%
So
cess.
the land was acquired under the National Highway Act,
Yes, my Lord.
not under the Act of 2000.
My Lord, our land was acquired under National Highway Act 1956. And since that deduction made by the respondent is illegal, because the provision of the Act it clearly indicates that cess can be deducted only when land is acquired under land acquisition law made by the state government.
Under Rule 47(4) of the Mizoram Land
The rules.
Revenue Rule
Yes, my Lord.
2013.
Yes, my Lord.
So under the National Highway Act, there is no provision for deduction of cess.
Yes, my Lord.
Yes, anybody appearing for the respondent?
Yes, Your Lordship. Regarding this
You are for respondent number?
respondent number 1, 2.
One.
1 and 2.
Respondent number 1 and 2.
Yes, Your Lordship.
1 and 2. And Madam for? 4. You are representing 3 also.
No,
Additional
No,
deputy
respondent number 3 is
commissioner.
Madhav Kala. Kala.
They have their own council. We
Okay.
are not representing Kala.
Okay. Anybody who represents NSIDCL? You.
Your Lordship, I'm appearing for respondent on behalf of my senior, Mr. Samuel Vanachata. He's representing respondent 5 and 6. He has instructed me
number
to
5 and
respond
6.
notice on his behalf. Your Lordship, he is currently out of station.
Let notice go at this recess. Let them obtain instruction. Heard me, sir. Your good name, please.
PC Lalthang Moya.
Learned counsel for the petitioner. And Ms. Yo, Ms.
Vanitsyami.
So learned government advocate for the respondent number 1, 2, 1 and 2. And Madam CGC for respondent number 4 and 4. Respondent number 4 and Ms.
Ay,
Learned counsel appearing on behalf of Mr.
Samuel Vanachata.
Learned conducting counsel. No, learned standing counsel for the respondent number 5 and 6. The petitioners herein are aggrieved for illegal deduction of 15% of the compensation amount as says by applying Rule 47 of 47 within bracket 4 of the Mizoram Land Revenue Rules 2013 in connection with building within bracket widening, structural landing, etc. Maintenance, management and operation of NI6 in the stretch of land from kilometer 138.55 to kilometer 141 within bracket Project Bhang, Kolasip district headquarters in the district of Kolasip. The learned counsel for the petitioner submits that the land of the petitioners were acquired under the National Highway Act 1956. But while making payment of compensation to the petitioners, the respondent authorities have deducted 15% of the sales applying Rule 47(4) of the Mizoram Land Revenue Rule 2013. And in the National Highway Act 1956, there is no provision for deduction of sales. And as such, the action of the respondent authorities are illegal and arbitrary, and therefore it is contended to interfere with the same. The submission of learned counsel for the petitioner needs further consideration. At this stage, notice be issued to the respondents, returnable in 2 weeks. However, no formal notice is required to be issued since all the respondents, oh no, you have to take step upon respondent number 3.
Number 3, yes, my lord.
Respondent number 3. Step upon respondent number 3 be taken by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the rest of the respondents since they are represented by the standing counsel. But extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 2 weeks. In the meantime, learned standing counsel for the respondent number 1, 2, 4 and 5 and 6 shall obtain necessary instruction and apprise this court on next returnable date. List accordingly.
Deeply obliged.
Item number 6.
May it please your lordship, this is a regular first appeal under section 17 2B of the Mizoram Civil Codes Amendment Act 2021, read with section 96 of CPC, against the impugned judgment and order dated 28th of August 2025, passed by the learned civil judge senior division 2 Aizawl in civil suit number 37th of 2021.
The relief granted by the learned, the order being passed by the learned trial court appears to
Yes,
be
trial court.
contradictory.
Yes, trial court, my lord.
Appears to be contradictory.
First of all, my lord, this present appeal is filed within a limitation and is requisite court fees and certified copies are also filed.
Within the period of limitation.
Yes, 90 days.
Okay. Heard, Mr.
Francis Lianboya.
Learned counsel for the appellant.
Yes, appellant.
There is a regular first appeal under section 17(2) within bracket B of the Mizoram Civil Court within bracket Amendment Act 2021, read with section 96 of the Code of Civil Procedure, is directed against the judgment and order dated 22/8/2025 passed by the learned Civil Judge Senior Division number 2, Aizal, in civil suit number 37 of 2021. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated 22/8/2025 passed by the learned Civil Judge Senior Division Aizal, Division 2, Aizal, in civil suit number 37 of 2021. Admit, issue notice to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned trial court. List the matter after 4 weeks.
Much obliged, my lord.
Item number 7.
May it please your lordship,
Yes.
this is IA number 24, IA number 210 of 2024 in connection with RFA number 54 of 2024. This is
So the matter was referred to the mediation,
yes, your
but
lordship.
mediation failed.
Yes, your lordship.
Now the office note the respondent number indicates that the respondent number 1 already suffered demise.
Yes, your
So
lordship.
you have to take step for bringing on a record the legal representative of the said respondent.
Your lordship, we have contacted his daughter, but they are unwilling to participate. They are uninterested. So even the
Then
notice.
we have to delete her name. They delete the name of respondent number 1.
Yes, your lordship, and also the matter can be taken up in his absence because no relief is sought from him. Relief is sought from the respondent number 2 to 5. He is only a proper party and not a necessary party, your lordship.
So will I strike out his name?
Yes, your
Respondent
lordship.
number 1.
Your lordship.
Heard means your name, please.
Sila Rimpui,
Learned counsel for the applicant.
applicant.
And anybody for?
Yes, Your
Madam,
Lordship.
you for
I'm
respondent number?
representing the respondent 2, 3, 4, and 5.
2, 3, 4, and 5. 2, 3, 4, and 5. The office note dated 4/7/2025 indicates that respondent number 1 suffered demise. The learned counsel for the applicant submits that though she has contracted the daughter of the respondent number 1, yet she is not willing to pursue the matter. And as such, she submits that the name of respondent number 1 may be struck off from the array of this application. Accordingly, taking note of the submission of learned counsel for the applicant, the name of the respondent number 1, it is provided that the name of the respondent number 1 be struck off from the array of this application at the cost and risks of the applicant. can we take up the matter today?
Yes, Your Lordship.
What is the ground for delay?
The ground for, if I may, Your Lordship, take you to the relevant paragraph that is from paragraph number 2 onwards,
Paragraph number 2.
to page number 3, Your Lordship. If I may read out, Your Lordship, that the learned trial court on 29/4/24 pronounced the order in connection with the civil suit number 24 of 2020, wherein the counsel for the applicant appellant at the lower court was also present. Even though the order was pronounced verbally, the copy of the order dated 29/4/24 was not furnished to the counsel for the applicant appellant. Therefore, on 21/5/2024, the counsel for the applicant appellant at the lower court applied for certified true copies of the order dated 29/4/2024, and the same was issued on 22/5/2024. On receiving the order dated 29/4/2024, the counsel for the applicant appellant at the lower court contacted the applicant appellant to meet her on 24/5/2024. Your Lordship, there's a the reasons for delay has been specifically mentioned in all of the paragraphs. So basically, the reason is that the previous counsel was in the midst of, preparing to file for the appeal, he was pursuing the examination for grade 1, Mizoram Judicial Service. And also the notification has been given under Annexure 2 and 3, that is in page number 22. And since he could not proceed with the case, a separate counsel was contacted, and the present counsel was contacted only on 19/11/2024. So confirmation was given. The present counsel said, intimated the appellant that she would need at least 3 days to confirm whether to proceed with the case. So from 22/11/2024, which is mentioned under paragraph number 8, Your Lordship, in page number 6.
Okay, your contention is that firstly there is a delay in getting the certified copy of the
Yes, Your
impugned
Lordship.
judgment and order.
Your
And
Lordship.
secondly, the counsel engaged by the applicant, could not pursue the matter on account of his preparing for Mizoram grade 1 examination.
Yes, Your Lordship.
Mizoram grade 1 judicial service examination.
Yes, Your Lordship. So the present counsel was
Yes,
contacted.
Madam, any
on-
objection in condonation of the delay?
Yes, Your Lordship, what I would like to mention is that regarding the merits of the case.
At
Your
the
Lordship,
time of hearing, not now.
I understand that,
Ah.
but still, if this continuation is, whether we have to hear the continuation of delay or not. So, Your Lordship, if I may take you to page number 10, the reason why the civil court has dismissed the civil suit filed by the appellant, that is because of limitation ground only. The reason. And the operative part is
Okay,
in
we will examine the order.
page number 12.
We will examine, first, let us admit the appeal.
All right, Your Lordship.
Heard Miss,
Sheila Rinpui.
learned counsel for the applicant. And also heard Miss so-and-so, learned counsel for the respondent number 2, 3, 4, and 5. This application under Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 138 days in preferring regular first appeal against the order dated 29/4/2024 passed by the learned civil judge senior division number 1 Aizal in civil suit number 24 of 2020. The learned counsel for the applicant submits that there was delay in furnishing the certified copy by the learned trial court, and also the counsel who was engaged by the applicant was busy in preparing where you have mentioned that he is busy in preparing for grade 1 examination.
Your Lordship, in page number 5,
page number 4, from page number 4, paragraph number 4.
In preparing to appear in the grade 1 examination of Mizoram Judicial Service. For which he could not attend the matter, and subsequently another counsel was engaged in his place, and only thereafter the appeal could be prepared and filed. And till the time of filing, 138 days elapsed, and that the delay is not intentional, rather it is circumstantial. And under such circumstances, he has contended to allow this application. The learned government advocate for the respondent number 2, 3, 4 and 5, however, submits that the civil suit number 24/2020 was dismissed by the learned trial court on the ground of delay. And there is no merit in this merit in the appeal, and therefore she has contended to dismiss the application. However, having heard the submission of learned counsel for both the parties, I have carefully gone to the petition, application and the documents placed on record, and also perused the order dated 29/4/2024, and also the statement and affirmation made in the application at paragraph number 2, 3 and 4. 3, 4 and 5. 3, 4 and 5. And it appears that the delay has sufficiently been explained, and the same is not willful and deliberate one. And under such circumstances, this court is inclined to allow this application. The delay of 130 days in filing the connected regular first appeal stands condoned. In terms of this, IA stands disposed of. In view of the order being passed in the IA number so and so, now the rest will proceed to register the appeal and list the same before this court as soon as practicable. It has already been registered. Appeal?
Yes, Your Lordship.
My Lord, I haven't received the appeal memo.
Yes,
You have not received.
we will be giving them by today during the course of the day.
The
Your
learned
Lordship.
counsel for the applicant, counsel for the respondent number 2, 3, 4 and 5 submits that she has not received a copy of the memo of appeal. The learned counsel for the applicant undertakes to furnish the copy of the same to the learned counsel for the respondent number 2, 3, 4 and 5 during the course of the day.
Yes,
You have the copy with you?
yes, Your Lordship.
Furnishing? So, list the matter on next Monday?
No, my Lord, I have to send the copy to the concerned department, and if the matter may be listed after 2 weeks, Your Lordship.
No. First, we have to admit this appeal.
All right.
We have not yet admitted. Monday?
Much obliged.
Supplementary cost list, item number 9.
May it please Your Lordship. My Lord, this criminal appeal is against the impugned conviction and impugned sentence passed against me, wherein I was sentenced to undergo 1 year 6 months imprisonment and with a fine of 1,10,000 rupees, and in default another.
How many years?
1 year and 6 months only, my Lord.
1 year, 6 months.
Yes, it is regarding corruption matter.
Okay.
Yes, my lord, there were 120 accused persons in the trial court in the present matter. And the allegation as a whole is that most of the accused persons who are the landowners, they claimed compensation in one project, that is KMM multi-model project in Longklai district area, wherein the allegation was that they claimed the compensation by using fabricated land passes. And most of the accused persons are the landowners. And the other accused persons, several persons are also the officials of the Lai Autonomous District Council, that is the issuing land passes authority, the revenue department concerned. And I am the circle supervisor, my lord, in that Lai Autonomous District Council revenue department. And all the accused persons except 2 persons had been convicted. And among 2 persons, I am the one, my lord. And I had been convicted under section 420 and 468 IPC, and also under section 13(2) and 13(1)(d) of the Prevention of Corruption Act, my lord. And your lordship, the allegation, short allegation against me is at, if I may take.
Okay, let us admit the appeal first.
Yes, my lord.
Heard, Mr.
Bill Ramenga.
Learned counsel for the appellant. You are for PP?
Yes, Your Lordship.
This appeal under section 27 of the Prevention of Corruption Act 1988, read with section 415 within bracket 2 BNSS 2023, is directed against the judgment and order dated 26/9/2025 passed by the Learned Special Judge Mizoram Aizal in SR within bracket PCA number 2 of 2018, arising out of ACB PS case number 1 of 2014. Full stop. It is to be noted here that I impugn judgment and order dated so and so. The learned trial court has convicted the appellant under section 13(2), read with 13 within bracket 1 within bracket D of Prevention of Corruption Act 1988 and section 120B, comma 420 and 468 IPC. And sentence him to suffer imprisonment for 1 year 6 months with fine of rupees 1,10,000 with default stipulation. Peruse the memo of appeal. Is it within time?
Yes, Your Lordship, within time.
When it was pronounced?
My lord, it was pronounced on 29/9/2025. Impugned judgment is 26/9. Sentence is 29.
And when did you file this appeal?
This last Monday, my lord.
27.
Yes.
Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated 20. What is the actual date? You have mentioned it as 26/9/25 and 29/9/25.
26 is the impugned judgment, my lord. Sentence was on 29/9.
29.
Yes.
Okay.
Impugned sentence.
Peruse the impugned judgment dated 26/9/2025 and the order of sentence dated 29/9/2025. Admit, issue notice to the respondents. You are representing respondent number 2 also.
Your Lordship, I do not have the records because it is mentioned. The record is not with me, Your Lordship, so I'm not very sure. It was mentioned and listed.
The respondent number 2 is the complainant.
Complainant.
No, Your Lordship. Only the state respondent.
You are for only respondent number 1.
Yes, the state.
No, he is under the state
Yes.
government, so you can represent
Okay,
him.
okay, yes.
Issue notice returnable in 2 weeks
2
or
weeks,
4
my
weeks?
2 weeks, my lord.
2 weeks. However, no formal notice is required to be issued since both the respondents are represented by learned PP. But extra requisite copy of the memo of appeal be furnished to her during the course of the day. Call for the recessal, call for the record from the learned tribunal. From the learned trial court. List the matter after 2 weeks. Then what is this IA?
IA is, my lord, for suspension of sentence and a conviction and for enlargement on bail. My lord, my submission is that I have good grounds in the appeal, and moreover he is suffering from lungs problem, and now the medical certificate is also there, and moreover the sentence is only for 1 year and 6 months, my lord. I have the supporting citation also, Your Lordship.
Pardon?
I have the supporting citation also.
Yes.
And I have 3 judgments of the Honorable Supreme Court, and thereafter I'll produce this Honorable Court's order also, my lord. Your Lordship, the first one is 2024 Volume 3 SCC 663 Atul alias Asutosh case, my lord. This is short judgment. I'll go to the next page, para 4, my lord. (2024) Volume 3 SCC 660. The second page, para 4, Your Lordship. Before parting with order, we must note here that notwithstanding several decisions of this court holding that when there is a fixed term sentence, and especially when the appeal is not likely to be heard before completing entire period of sentence, normally suspension of sentence and bail should be granted. And the next one is, my lord, Kiran Kumar, that is 2001 Volume 9 SCC 211, para 3. Para 3 says, my lord, this court has held in Bhagwan Rama Sinde Gosai versus State of Gujarat that when a person is convicted and sentenced to a short term imprisonment, the normal rule is that when his appeal is pending, the sentence should be suspended and rejection is only by way of exception and be put forward for such a rejection. And the last one is, my lord.
What is the profession of the appellant?
He is the government servant, Andalai Autonomous District Council. He is the circle supervisor. That is why, my lord, I am praying for suspension of conviction as well as sentence during pendency of this connected appeal. And while relying upon, I may rely upon your lordship's decision in this, my lord, IA Criminal 7 of 2025. I may produce before your lordship. I have given to the bench assistant. Yes, my lord. That is IA Criminal 7 of 2025. This is also corruption case, your lordship, wherein your lordship had granted suspension of the conviction. The present applicant is also in the similar footing, my lord.
Yes, madam, any objection?
Your Lordship, I'll leave it to your wisdom, Your Lordship.
No, regarding suspension of conviction. Suspension of sentence is all right. But he prays for suspension of conviction also.
Your Lordship, only the I do not have any objection with regards to suspension of sentence only. With regards to conviction, Your Lordship, I think I will have to look into the matter.
Your Lordship, your Lordship had also passed one order in this.
No, that's all right. That
Yeah.
was a different matter.
Mm.
Different in the sense that
Or in that case, your Lordship,
the respondent authorities in that matter proceeded to take departmental action against the applicant, against the accused.
I see.
Therefore, that was the necessity. But in your case, perhaps it is not the necessity.
Not yet started. So in that case,
First,
your Lordship,
let us do one thing. Let us suspend the sentence now.
yes,
If any exigency arises, you can mention the matter.
yes, my Lord, for suspension of conviction,
Conviction.
afresh,
Yes.
filing a fresh application. My Lord, I'll be very much obliged.
Heard Mr. Lal Rem Nahiga, learned counsel for the applicant, and also heard Ms. So-and-so, learned PP for the respondent, opposite party. This application under section 430, which will make it 1 BNSS, is preferred by the applicant for suspension stroke stay of the impugned judgment and order dated 26/9/2025 and the order dated 29/9/2025 passed by the learned special judge, Prevention of Corruption Act Mizoram Aizal in SR, which will make PCA number 2 of 2018, arising out of ACP PS case number 1 of 2018, dated 16/4/2014 under section 13, which will make it 2 under section 13, 1D of the Prevention of Corruption Act 1988 and section 120B, 420, 468, 471 IPC. During the pendency of the connected appeal preferred by the applicant stroke appellant for allowing him to, and also for allowing him to go on bail pending disposal of the appeal. The learned counsel for the applicant submits that the applicant is serving as
Circle supervisor,
circle supervisor
yes, in the
In-
revenue department,
in
revenue department
In
in
revenue
Lai Autonomous,
department.
Lai Autonomous District Council.
Lai Autonomous District Council, Lai Autonomous District Council, and he has been convicted under section 13(2), 13(1)(d), read with section 120B, 420, 468, 471 IPC in SRPCA number 2 of 2018, by impugned judgment dated 26/9/2025 and sentence him to suffer imprisonment for 1.5 years and also to pay a fine of rupees 1,10,000 with default stipulation, and that the applicant has already preferred an appeal, being criminal appeal number 28 of 2025, and the same has already been admitted by this court today, and notice has been issued and the record has also been called for from the learned trial court. And since the conviction is for a fixed period and less than 2 years, there is a requirement, and since the applicant has been serving as circle supervisor, there is a requirement for staying operation of for suspension of the sentence, handed down by the order dated 29/9/2025. The learned counsel, learned PP submits that he has no objection in suspension of sentence of the applicant. Accordingly, having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record and also First is the impugned judgment and decree, judgment and order dated 26/9/2025 and the order dated 29/9/2025. Passed in SR PCA number 2 of 2018. It appears that the applicant herein is convicted under section 13(2), read with 13(1)(d) of the PC Act, and also under section 120B, 420 and 468 and 471 IPC, and sentenced to suffer imprisonment for a period of 1.5 years and also to pay a fine of rupees 1,10,000 with a default stipulation. Accordingly, taking note of the submission of learned counsel for both the parties, the sentence so handed down by order dated 29/9/2025 upon the applicant stands state till disposal of the appeal. Till disposal of the appeal. In terms of this, I stands dispose of.
My lord, I may be allowed to go on bail. That may kindly be mentioned.
Trial court has already allowed you to remain on previous bail?
No, my lord, it was rejected.
No.
Yeah, I preferred bail application in the trial court, which was rejected, my lord.
Okay.
I have annexed the
The
copy.
learned counsel for the applicant also submits that the applicant has preferred an application for granting him bail, but the same was dismissed by the learned trial court, and accordingly he submits that the accused, the applicant may be allowed to go on bail till disposal of the appeal. Accordingly, taking note of the submission of learned counsel. Any objection, madam? No. Learned counsel for the applicant and also of the learned PP. This court is inclined to allow the applicant to go on bail on furnishing a bond of rupees. What was the earlier bail amount?
My lord, it was anticipated. My lord, I'm so sorry to say that I'm not sure about that, my lord.
On furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned trial court.
I'm highly obliged, my lord.
Any other matter? The other matter is this hearing matter was there. No, hearing matter you send the record to the chamber.